some technical issues sending out the links, so please keep on corresponding with Danae and Adal should you have any issues, and they will quickly assist you from that side. They're doing technical support. And while the rest of the guys are joining, my name is Anke de Wet, and I work with Morris Botha Consultants, and I mostly attend to the contracts. And we specifically decided to host this session because we realized that quite a lot of our schools have issues with contracts on a regular basis, whether it be contracts with service providers or employment contracts or rental agreements or whatever. There are always some issues with contracts, and we felt like we should have this session so that you guys can have a bit more information and knowledge on what to know and how to deal with contracts. Before we start, if you have any questions, Danae will be monitoring the questions and giving them to me at the end. So please put your questions in the chat function. We're not going to do questions throughout the session because it's a bit difficult to do the whole presentation and answer the questions in between. So Danae will be giving me the questions at the end. If you want CPDD points, please email Adele like we indicated yesterday. Danae will also include the necessary arrangements in that regard in her email that she will be sending after the session, where we will be sending the PowerPoints in both English and in Afrikaans. So the sessions are done in English, but you will get the PowerPoint, the same PowerPoint in English and in Afrikaans. And also we recently started a Facebook group, Morris Botha Consultants Facebook group. So please feel free to go and like that group, and we'll be sharing important information or just interesting information with regards to education in general on that Facebook page. So I think we can start. It is 12, so I think I'm going to start with a session. I'm just moving this away quickly. Okay, so why are contracts important? Number one, for protection of the school in contractual disputes. So especially with last year and COVID, or in general, if whoever you reached an agreement with is not performing in terms of the agreement, the contract is what you go back to force that person to do what he needs to do, or to do something else, to cancel the contract. So the contract is so important, because if there's a dispute between the parties later on, that is where we will have to go to protect the school and to sort out this dispute. And if the contract either doesn't exist, or if the contract isn't complete, then it makes contractual disputes so difficult to sort out. So that is very important. That's the base point of any relationship between two parties, is a contract, and that needs to be, number one, in place, and it needs to be complete. So contracts are interpreted also. So we have definitions in our contracts, specifically to define certain concepts in the agreement that are more important to us, or that are that appear in the contract more than once. Then contract needs to be complete. Say for sometimes there is a referral to an annexure in a contract, but when you find the contract or the school sends the contract to you, that annexure is nowhere to be found. So make sure your annexures are also there and they're also initialed, and that everything that needs to be in writing is actually contained in the contract, because most contracts contain a paragraph that says that if something hasn't been put in writing and signed by both parties, it does not form part of the agreement. So make sure that whatever is negotiated between the school and this person, whether it be an employee or a service provider, make sure that everything that formed part of the negotiations are actually included in the contract as well. Then number 4 and number 5 actually are interlinked. So we especially saw with COVID that the economic circumstances of our schools changed. And a lot of them contacted us and said, look, we need to get out of this agreement. And we can't pay for this anymore. And then we looked at the contracts and, either we asked for the contracts and then the school said, but we never reached an agreement in writing with these people. So that causes enormous problems in the first place. And then secondly, maybe there was a contract, but the contract doesn't address how parties can get out of the contract. I've seen so many contracts that just says this contract is valid for this time frame, and if there is breach of contract, then this can be done. But it doesn't give the parties any other way to get out of the contract whilst this contract is still ongoing. So you can think of maybe you get someone for your tuck shop, but they're really not performing, or the school's circumstances change, the operational requirements of the school change, and you just don't need that specific service provider anymore. But the term of the contract hasn't been completed and no one has really done something wrong. It's just that the circumstances that the school's changed. Then there needs to be some kind of clause to say you can get out of this contract at any time by giving the other party a month or 2 months or 3 months of notice, a reasonable notice. And then lastly, termination. We also found that those clauses to terminate the contract that I just spoke about, also they are just not contained in the contracts, or they are set up in such a way that it basically makes it impossible for the school to terminate the contract. So what a lot of our schools do is before they sign contracts with service providers, they actually send it to us to go through and ask us, does this look okay? Or they go through it themselves and they send us the clause that is bothering them and ask us, what about this clause? Is this clause okay? And then we can assist you. So it's much easier to assist you before you have signed this contract and reached this agreement than it is to assist you on a contract that was concluded already, signed already, but now you need to get something out of it, but the contract doesn't provide for that. So I think that is why we need to do this session with you guys. So what contracts am I talking about when I'm talking about contracts that are relevant at schools? So number 1 is definitely the school's employment contracts. So that is the one that is the most important, I think, the most relevant contract that you guys deal with very frequently, and we also assist you guys with very frequently. We have standard contracts, English and Afrikaans, for most types of employment arrangements. And should a school then have a specific need, we're always there and able to assist you to amend our standard contract to suit your specific needs. We find that schools have employment contracts, maybe 5 different ones from 5 different generations in the school, but now no one is exactly sure what applies, what doesn't apply. So employment contracts should actually be the same contract for all people in the school. It will really be so much easier to deal with any and all employment matters if all the contracts are the same and all the contracts are updated. But we'll go into more detail with employment contracts as well. Then contracts with independent contractors. So those are, we'll also discuss that. Those are your sport coaches, for instance, or the person's appointed to come and direct your choir. Those are independent contractors. And then rental agreements. So normally with schools, they sometimes rent out their tuck shop or their clothing shop. Or alternatively, some schools actually have property on the school grounds that people can rent. And then you'll have rental agreements with employees of the school staying on the school property. Those rental agreements are also relevant. And then lastly, contracts with service providers. So those are the people providing the school with printers, bottled water, paper, stationery, clothing, anything like that. So those are mostly the contracts that we deal with and that we will be discussing today, because we have found that those are the contracts that we assist you guys with the most. So starting with employment agreements. As I said, it's the most important contract at schools. And why is it important? Because it regulates the relationship between the employer and the employee. So it determines how we deal with one another and what the responsibilities of both parties are. And if you have a well-drafted employment agreement and it is complete and it's up to date, then it really assists the school in dealing with any types of disputes that might come up. So it's really important to look at your employment agreements. If you know your school's employment agreements are very old, please, we've sent out our latest employment agreements last year, but please, if you don't have it or you don't know where it is now, that email, please contact Adele and ask her to send it again. There are some updates that happened, for instance, with regards to POPI, where the employees give the school consent to process their personal information for as long as it's necessary to regulate the employee-employer relationship. And we also added a brand new clause with regards to drug and alcohol testing to our contracts, because we found that there are young educators at school who are getting into trouble with drugs and alcohol, and we wanted to put that in the employment agreement so that you don't even have to ask consent when you test them, because if they've signed that employment agreement where we put that clause in to give consent beforehand, then it's so much easier for you to deal with that situation. So please contact Adele should you need up-to-date employment agreements. We update our employment agreements as we work. Every time we deal with a matter at a school and we find that there could have been some clause in an employment agreement that could have assisted the school, then we put that clause in. So we will send you employment agreements at least once a year. And if there's very big changes, we'll also send it more often than that. But I know all the schools have their own rhythm of when they do their contracts. So consider next time when you do your contracts to review your contracts properly. Ask us to come and assist you. And we can make sure that your agreements are up to date and complete. Okay, so one of the biggest issues at schools and one of the places where schools are really suffering in this regard is fixed term contracts versus permanent contracts. Most schools over all the years used to only sign fixed term contracts with all their employees. So every year, every person employed by the governing body would be getting a new employment agreement for the next year that would only be valid from January to December that year. Now, this is where the problem comes in. Section 198B of the Labor Relations Act was brought in, and that determines that any person employed by the school who earns less than that amount, 205,433 Rand and 30 cents per year. If someone earns less than that per year and they've been employed by you for more than 3 months, the moment those two conditions are made, then they are regarded as permanent employees. So if someone started working at the school in 2015, and you've been giving them the same contract year on year on year, then they are regarded now as a permanent employee. Even if someone earns more than that amount, but you keep on giving them a new contract each and every year, they also become permanent employees. So schools can give these contracts year on year on year, but if this matter comes to the CCMA, where there's a dispute and payment has to be made out to the employee, or if there is something like a retrenchment and the employee's severance package has to be determined, the CCMA will look at the first date of employment, even though the school had given that person a year on year on year new contract. So when can I use a fixed term contract? Because they are allowable, but only under very certain conditions. And the requirement stated by the CCMA is that if I appoint someone on a fixed term, I have to put in writing the reasons why that fixed term is reasonable and justifiable. So fixed term contracts are only valid if the nature of the work for which the employee is employed is of a temporary nature, or there is another good reason to justify that temporary appointment. So this is not really enough information. Let's give you more information. So the Act actually gives us examples of when a fixed term agreement will be reasonable and justifiable. And I put them ones mostly that we've mostly found at schools. I put them on this list. So number one, if the employee is replacing another employee who's temporarily absent from work due to illness or maternity leave, those 4 months, that is a fixed term agreement you conclude with that person coming in on a temporary basis for 4 months. Someone going for an operation and you appoint a teacher for 6 weeks or 8 weeks, that is a valid fixed term agreement. Secondly, if there is a temporary increase in the volume of work not expected to endure beyond 12 months. So with COVID, we found this because some schools had to appoint extra cleaning personnel because of the COVID requirements and all the cleaning that has to be done on a daily basis. So when COVID is over, those people will most probably not be necessary because the volume of work will go down again. Or the school is arranging their festival because the school is turning 100 years old or 50 years old, and they appoint a person just for a few months or a year to do all the arrangements for that function. That is also a temporary increase in a volume of work, and it's the same as for the specific project, the third one. So the specific project can also be this function that needs to be arranged. Let's look at the rest. The employee has reached the normal or agreed retirement age. So we found, especially last year when we had to start doing so many retrenchments, that schools contacted us and said, no, but this lady has been working at the school, but she's long past retirement age. And then we asked the question and said, but so when did she turn, say for instance, their retirement age is 65. And then they said, no, she's already 68, but she's still working here because she really knows what she does. And then second question we ask is, okay, but did you give her a new fixed term agreement when she turned 65? And very little to none of our schools had done that. And we also found that a lot of our schools didn't even have retirement age in their agreements. So I'll talk about retirement a bit more, but one of the very specific times you are allowed to only reach a fixed term agreement is when someone is past retirement age. You can imagine your matric maths teacher who turns 65 in May, but you really want her to stay on to finish with her matrics until the end of the year. So you make her retire, or you have her retire when she turns 65 in that month of May, and you enter into a fixed term agreement with her for June until the end of December. Because why? If that lady needs to be retrenched after she has reached her retirement age, and you had never given her a new fixed term agreement, you will be paying a severance package from the first day that she started at the school. Now you might think, but sometimes there are people who work at schools for 20 years, 15 years, 10 years. Then that severance package gets rough. I'm just going to ask Danai to let me know if people can't hear me. It's raining quite profusely here. Okay, let's continue. The employee is a student or a recent graduate who's employed for the purpose of being trained. So a lot of our schools employ students who are still studying, and those students are then employed for that time frame that they are studying. And the moment that they become qualified, then that fixed term rule will not apply anymore. So appoint all your students who are still studying and being trained, appoint them on fixed term agreements. We have a special contract for students because with students you have leave for exam purposes, leave for study purposes. You have to say that they need to give you proof that they've actually registered to be a student. They need to give you some form of feedback in terms of have they passed, have they not passed. Because if that student has finished his or her fixed term agreement with you, but they have not passed their studies, but they should have, then that agreement should come to an end. Because we sit with schools who never end those agreements, and those people are still employed by the school, but they never ever finish their studies. And that becomes a real problem because at some stage that relationship is not what the school wants anymore. They need a SACE qualified educator who is fully qualified to do the job. Okay, so when does this come and bite you? If your employment agreements are not correct. Number one, mostly CCMA cases. So if your employment agreement doesn't protect you as the employer and an employee takes you to the CCMA, it's going to bite you. And then also a lot with retrenchments. So I've touched on it a little bit. But if your employment agreement is not up to date, it's not complete, it's not catered to the specific needs of your school, and you need to do retrenchments, which a lot of schools have had to do, unfortunately, due to COVID, then that's also going to become an issue. So it's not when it's going well, it's when it's going bad. And our advice would be is do this whole thing once. Get your employment agreements in place, make sure they're updated, make sure they're complete on a regular basis, and if these things come up, then the school is protected. Okay, so now we're going to look at a few things with regards to employment agreements that we get a lot of queries on, or general questions, or things that we've picked up. So take note, the minimum wage is currently 20 Rand and 76 cents per hour. So go and take a look at your employees who get paid the least and go and make sure that they are at least earning minimum wage. That is basically what the most important thing about that, because it increased, I think, at the beginning of last year. So maybe not all schools are aware that it has been increased from the first one that was announced. Okay, sick leave. So sick leave, the Act says it's the amount of days that the employee normally works over 6 weeks. So that works out for people who work 5 days a week, it works out for 30 days. And that is in every 36 months worked. And here I want to say very clearly, you are not allowed to say that that person only has 10 days a year. You cannot split it up because they can take 30 days in 1 year. If they had a big accident or something, they can use up all of their 30 days in 1 year. You cannot make it only 10 days a year. Only if someone is appointed on a fixed term basis, you can do that, a kind of a reduction in that days per year. And you will see in our fixed term agreements, we do that for you. But you cannot, with a permanent employee, reduce that amount and make it a yearly amount of days. That is not what you can do. So the question will be, if someone uses up all of his or her sick leave days, what then? Then you tell them, look, you've used up all your sick leave days. Maybe they have annual leave days left. Then you can give them their annual leave days. But what if they don't have annual leave days and they don't have sick leave days? All of it's used up. What do you do then? Then you ask them to come back to work. And you have an incapacity hearing with them. You don't just leave them way beyond this period, or you pay them even though they're not working. You bring them back and you do an incapacity due to ill health. We'll talk about it a bit more later. and you get them out of the system, or you get them to talk to you and tell you what is happening. You don't leave it. We get schools who are paying these people who leave this, and the people have used up all their sick leave, all their annual leave, and the school just leaves this matter and they don't do anything about it. But you need to appoint someone new in that person's place. So if you have a matter like that, please contact us. Let us help you with the incapacity procedure or a different consultation to see if everyone just can't go their own ways in an amicable way. Working hours, the Act says there's a maximum of 45 hours per week, but the departmental, not the educators, the normal departmental staff, they work 40 hours per week. So a lot of schools rather have everyone work the same amount of hours, because we get a lot of issues, especially with general assistants, terreinwerkers, where if the one group gets more hours and the other group gets less, or the one group gets more leave and the other group gets less leave, that becomes an issue. So all these things that I'm talking about now, I'm basing it upon what the Basic Conditions of Employment Act says and the Labour Relations Act says. So I'm not talking about departmental employees, I'm only talking about employees employed by the governing body, and I'm talking about what the standard is that the Act requires. So nothing prohibits the school to be better than the standard that the Act requires, but you cannot give these employees less. You can give them better conditions, you cannot give them worse conditions. Because we do find that schools try to give governing body employees the same than what the departmental employees are getting. And it does make sense because it avoids disputes, but not all schools can afford that. So you do not have to give them what the departmental employees are getting. You must at least only give them what the Act requires, and that is what I'm giving you here. Please also note that do not now go and, if you've always given these people the same as you've been giving departmental staff, say, but the Act says I only have to give you this. If you've created year after year a certain environment, and then that becomes part of that agreement between the employer and the employee. It becomes an accepted labor practice is the term that we use. So if you've always given them more leave days than they actually should get, like I'll explain now, you cannot now just take it away. You will need to consult with them to explain why. But if you've created that accepted labor practice, you will have to keep that up. But when you employ new personnel members, and when you haven't done that yet, be very careful to do it, because you don't have to. You don't have to give everyone the same, because they're not employed by the same employer. So annual leave is, according to the Act, 21 consecutive days, and that is equal to 15 working days. That is what you have to give them. You can give them more. So our contracts are also based on what the standard is. You can make it more. You can ask us and say, but we do this at our school. How do I word the contract? And then we'll assist you with that. When can annual leave be taken? So we'll say in our contracts, annual leave has to be taken during official school holidays. Why? Because the school needs to be operational. So we actually put that sentence into our contracts. And then some schools have some employees returning earlier so that the school can be made ready for when learners and teachers return. So that we physically write into the contract. So there can't be any issues later on if it's not written in the contract and then you suddenly want to make them do something. Rather, if you know it's the practice at your school, let us rather write it into your contract and we know that is there and they've signed it and they can't give you trouble at a later stage. Then I want to warn you, we have found schools who pay out annual leave. So if someone has only taken 5 days of annual leave and then the school pays out the rest, you are not allowed. The Act does not allow such payments. You are only allowed and required to pay annual leave when a person leaves your employ. So when they are dismissed or when they resign, then you pay their annual leave that is left at that date. So if they resign today, you pay them the annual leave that is due to them on that specific day. You cannot pay annual leave out at the end of every year. We have found schools who paid out in the form of some kind of bonus at the end of the year. It is not allowed. It is against the law to make such payments. So please do not do that. If you have been doing that, we have a letter that you can use, and we will come out and explain it also to your employees if necessary, but we have a letter that we drafted that you can send out to your personnel explaining that this is against the act to pay out annual leave, except if employment is terminated. Okay. Then lunchtime and tea time. So the act says you must give your employee at least 1 hour's break after 5 hours of work. But the act also says that you can shorten this break to 30 minutes, the minimum of 30 minutes, in an agreement. What agreement? The employment agreement. So that it comes back to the employment agreement every time. So if that is the practice at your school, then write it into your employment agreement. You will see also a lot of schools, rather than giving an hour's lunch break, they, for instance, give 45 minutes lunch break and a tea time of 15 minutes. That is fine, but write it into your employment agreement. Okay. You can also do away with lunch if the person works less than 6 hours per day. You will also note that our contracts have a clause that says that the employer and the employee can make arrangements or agree otherwise in terms of lunchtime and tea time with reference to the operational requirements of the school. But you must know that you're not allowed to tell someone they cannot go on lunch. If they want to go on lunch, they have to go on lunch. Okay, special leave. I've found a lot of schools who have special leave in their governing body agreements. You do not have to give your governing body employees special leave. So dis daai dringende privaat sake verlof in Afrikaans. So you have family responsibility leave in the Act for 3 days. But special leave is actually something that departmental personnel get, but it's not something that is a legal right for another employee who is employed by another employer. So, but a lot of schools have already implemented it. And like I warned earlier, if you've created this practice at your school, you can't now just go and take it away. But be careful, you do not have to give special leave. You can if you want to. As I said, you can give more than the Act requires. You cannot give less. Okay. Retirement. I spoke about it earlier. Does your school have a policy with regards to retirement? Does your school's employment agreement state that a person retires at the end of the month in which he turns or she turns 65 or 60, or at the end of the year? So a lot of schools prefer saying at the end of the month in which the person turns 65 or 60 because they find it's difficult to get the people out of the system. Other schools prefer having the person stay on until the end of the year in which they reach that age due to the operational requirements of the school. So for every school that is different, you have to look at what is your school's requirement, what works best at your school. If your school does not have retirement in its contracts, you need to add it. If you're not signing our new agreements and you want to use your old one, we need to at least do an annexure that explains this retirement position and both parties need to sign it, or you need to implement a policy with regards to retirement at your school. But do not just leave this. This is what will bite you if you don't put it in when it comes to retrenchment. When it comes to paying out the severance package for someone who has been at the school for 15 years, because you pay 1 week for every year that the school has employed that person. So go and check if retirement forms part of your school's agreement. If it doesn't, if you at least have a policy on it. If you don't have either, please start using our new contracts. If you want to use your own, let's do an addendum to assist you. Okay. Guys, we get so many issues on this. We get emails and phone calls from schools saying, please send us a letter to terminate this person's service. It is not allowable. You cannot just give someone a letter and tell them, sorry, you're not working here anymore. That is not allowable. Okay. You must follow specific procedures, and I'll give you a bit more detail. But before we get to that, some schools say that educators need to give them 3 months notice when they resign. Okay, and that makes sense because school terms and the fact that you need to find a new teacher in that person's place. But when this comes to bite you, when you want to give that person notice, when you're retrenching them, you also have to pay that person 3 months notice or have them work 3 months notice. So if the school's finances are in a really bad state and you literally cannot afford to pay that person 3 months more salary, then this is a really bad notice period to have in your contract. So I know it works better for the school to get more time, but we all know that we get those educators who literally just resign and leave, and they in any case don't work those 3 months. So think about using 1 month versus 3 months. Go and think about that. We prefer 1 month. If your school prefer 3 months, that's fine. But remember, if ever you have to retrench that person, you will be having that person on your payroll for 3 months from the date that that person you actually wanted them to leave your employee. So you need to pay them for 3 months. Then a quick explanation. Month, this is calendar month. Okay, so if you just say month, then someone can come to you and say, but on the 15th, I'll give you notice, and then by the 15th of the next month, then my notice is done. But that doesn't work nicely, does it? So we want to describe month as a calendar month, which means the month runs from the 1st until the 31st or the 30th or the 28th if it's February. So that is also something that you'll find in our contracts, something to consider, the way you explain a month's notice or a calendar month's notice. Okay, terminating someone's service. You are not allowed to tell someone, sorry, you're not working here anymore, here's a letter, thank you, goodbye. Not at all. The only way in which you can terminate an employee's service with the school is by following Schedule 8 of the Labour Relations Act. And that Schedule 8 only provides for these 4 that are listed here. 1, misconduct and disciplinary action. Someone does something, an educator slaps a kid or steals something at school or whatever, anything like that. There's misconduct, or maybe this person has had a few written warnings and then a final warning, and then that person gets dismissed. But only after disciplinary action has been taken. Only after these warnings have been issued. If it's a very serious thing, then you have your hearing and you can dismiss that person at his or her first hearing. But that hearing has to take place. So that hearing needs to take place, and then you can dismiss that person, and then that person's employment is terminated. Okay? Then you have retrenchment or operational requirements. A lot of schools had to do this last year, where the school cannot afford to pay everyone anymore, and the school goes and look at his whole salary bill and decides that this group of people, they are not essential to the core business of the school, which is learning, teaching and learning. It's the extra that the school has, then that group might be identified to possibly be retrenched. Okay. And the other time when retrenchment or operational requirements is restructuring. So the school decides that they'd always done something internally, but they're now going to appoint an outside third party to do it because it's going to be much cheaper to do it that way. Then that will be a restructuring. But with both, actually all these procedures that I'm listing, if ever any employee's services needs to be terminated, whether it be for misconduct, retrenchment, or incapacity, please phone us. Please phone us. Please email us. Please tell us what's going on. With misconduct, there will have to be a notice of disciplinary hearing and a charge sheet. We will assist you. We will assist you with the process. In serious cases, we can come and sit as chairperson to do the hearing. With retrenchments, please don't try and do it by yourself. Please ask us. We can either come and do it for you, with you. We can help you prepare all the documents and you can do it yourself, but we can guide you. Because schools make mistakes because they don't know better. And if you are a member or you know about our services, you don't need to make those mistakes and you don't need to go and pay for those mistakes at the CCMA. Okay. Then we have incapacity and poor work performance, and also illness. So poor work performance is someone is just not, their work is just not up to standard, but you need to take steps. So you need to have sessions, you need to do training, you need to be able to show, and you need to have documentary proof where you guided this person to better their work performance before you can terminate their service. And also there has to be a hearing before that can be done, or a process, a consultation process. Same with illness. If someone gets ill and cannot perform their duties, you cannot just tell them that sorry, but you can't work here anymore. There's a process. There are consultation that needs to be taken place, medical reports that need to be lodged. So please, if ever you need to terminate employment, those are the only ways you can do it. And the last one that's not on here is mutual separation can be agreed upon. So both parties can sit around the table and say, look, this is not working for either of us. Let's reach an agreement to rather go our separate ways. Maybe there will also be a severance there included, and then that's done. But then there needs to be a contract that's signed afterwards to protect the school so that person doesn't come back and say, but the school treated him or her unfairly. Okay. Annexes to employment contracts. So a job description is essential. It's a legal requirement to give someone a job description. Make sure that you have a job description for every contract and that job description is complete and that it's kept up to date. If the person's job description changes with time, update the job description, please. Then the last two are interlinked. A code of conduct for employees and a disciplinary code and grievance procedure. So how do employees know that they are doing something wrong? And that is contained in the code of conduct for employees. It's very important because it strengthens the school's hands so much if you can have a disciplinary hearing and refer to a code of conduct that the employee has signed somewhere since he or she has been appointed. Because then you can show that that person knew that there was a rule, that the rule existed, but they still did not adhere to the rule. Okay. But you must apply this consistently and regularly. So you cannot apply the code of conduct to only certain people you don't like. Everyone, if they do something wrong in terms of the code of conduct, there needs to be a consultation or a counseling or a written warning or a verbal warning or even a hearing. Everyone needs to be treated the same. Okay. The disciplinary code then tells us how do I implement disciplinary procedure against someone, what are the steps that I need to take, and the grievance procedure says if an employee has a grievance in the workplace, then what do they then do? How do they give the employer this grievance? How do they lodge it and how is it solved? Okay. I'm sorry, it's raining really hard here by me. I hope you can hear me well. Then we have independent contractors, okay? So we found schools in COVID that had appointed persons who only spend like 1 hour a week at school as employees. Please don't do that. Please don't do that, because it automatically means if the school hits hard times and needs to retrench, you need to pay that person a package. But they're not actually even an employee. They're not supposed to be an employee, but you gave them an employment contract. And now you need to give them everything else that an employee has the right to when services are terminated. So any person working less than 24 hours per month should not be appointed as an employee of the school, but as an independent contractor. Your sport coaches, your counselors, your social workers, your choir conductor, normally they are not employees, they're independent contractors. But if they work more than those 24 hours, they have to be appointed as employees. So it's to avoid labor disputes and responsibilities, because if you are in an employer-employee relationship, there are lots more responsibilities on the employer than there are with the independent contractor, because then it's a contractual agreement and it can just be cancelled, and there's nothing about severance packages and all those things. No CCMA, etc. Okay. Rental agreements. Please go and look. What is the term of the agreement? Please don't enter agreements more than 3 years if it's not absolutely necessary. Who will be responsible for maintenance? You're renting out your tuck shop. Please put that in the agreement. We have standard agreements for that as well. What happens if rental is not paid? You have to go and look at your contract. The contract should say that that person needs to be informed that they are not adhering to the terms of the agreement, and that they should be given 7 days or 10 days to fix that problem. And if they don't, you have the right to terminate. So what schools do, they do nothing. So this person who has a rental agreement with the school are not paying. That person is not paying for 6 months or 12 months, and the school does nothing. And then after 6 or 12 months, the school comes to us and says, yo guys, but what now? This person owes us 17,000 Rand, and what should we do now? The moment someone defaults, you should issue them with that letter. The moment they don't pay, they should be out. I know it's not always as easy. I know schools function differently. I know it takes time to get the governing body ready, but please don't wait for 6 or 12 months and then you sit with this huge rental account that you probably will never get back. Please don't do that. That is where your agreement will protect you. If you follow the steps indicated in your agreement, you should be fine. Okay? If the school's equipment is being used, maybe there's a pie oven or whatever that the tuck shop is using, indicate that in the agreement and make sure it indicates that they need to return it in the same state or condition that they received it, and that they're not allowed to remove it from the premises, for instance. So think about that as well. Then service providers, also, what is the term of the contract? Please don't go into contracts for more than 3 years. I know the printer people normally don't go into shorter agreements, so there are certain circumstances where a longer contract is justifiable. Then, I spoke of it earlier. How can the school terminate the contract? I've seen too many contracts with service providers that don't provide for the school to get a way out. Please don't sign a contract like that. Please ensure that the terms of the contract is clear on what happens if there's a breach and what happens if the school wants to get out of this contract, even if there isn't a breach. Okay. And what can the school do if the service provider does not perform? It goes back to the contract. Go to your breach of contract clause. Maybe there isn't one. Then please don't sign that contract. There has to be a remedy for the school if the service provider does not perform. And the same with rental agreements. If someone doesn't perform, they need to be warned in writing, and the school needs to take the steps as prescribed in the contract to be able to terminate at the end of the day. And that is it. I'm so glad we finished in time. Danae has indicated to me that there was a question and that she will gladly answer it. So Danae is an expert on employment agreements, mostly, and especially retrenchments and incapacity. So those types of queries, you're always welcome to actually ask Danae about it, and she will be able to assist you, and then I'm also always there. So please don't feel like you're alone with this. We are here to assist you always, and please send us an email or phone us rather than signing something you're unsure of. Okay, I'm giving over to Danae.
Okay, thank you very much, Anke. I think it was very informative, and it's always good to hear what you have to look at before signing an employment agreement. So the question that came in from Dave also relates to signing an agreement. So his question is, may you include a COVID-19 stipulation in a fixed contract for, say, a sports coach contract? So he says, for instance, commencement of contract is subject to COVID regulations at a certain level. So I'm going to answer this question in two parts. So firstly, there's a very gray area with regards to what should be considered when a contract is entered into. When is the commencement date? When does the employment relationship start? So there is various interpretations of this. So how employment is dealt with before the actual work starts, that's the gray area. Anke also mentioned that when we consider sports coaches or choir coaches, drama, anything like that, it's better to put it rather in the form of an independent contractor agreement, because it doesn't create that relationship. So the position at this stage is that once you enter into an employment agreement, even before work commences, that the relationship is already established, meaning that should you want to cancel the agreement even before the actual work starts, you will always have to still comply with the Normal Labor Relations Act. That also means that that the employee should also receive his benefits, let's say sick leave and things like that, even then before the employment agreement started. So our suggestion is, don't offer the position until the candidate can actually take up the position. And I know in some instances there's really good sports coaches that the schools want to keep for themselves, and COVID-19 is making it really difficult. So we would rather suggest that you then enter into an independent contractor agreement that will have the clause that if there is no work being done by the sports coach, that the person won't get paid.
Okay, thank you guys. Any other questions? We're quickly just checking if there are other questions posed here. Okay, David, I do have a clause like that for an independent contractor agreement if you want to contact us for that. But I agree with Danae, rather appoint them as independent contractors. It depends on the situation of your school, so please let us know if we can assist you if you have any specific needs. And that's it, guys. Thank you so much for joining us. I hope you learned something from this. We've really found that schools have been struggling with contracts in some sense or ways. So yeah, please contact us and know that we are there. Have a good afternoon. Bye.